Good day, ladies and gentlemen, and welcome back to another What If video. In today's video, I will be unpacking what if an employee operates a side business which is not in direct competition with the employer. As we know, some employees will look to earn additional income, and this may result in moonlighting. But the question, however, is whether employees need to disclose their side business or side hustles to their employers. I think we can all agree that in cases where the side business is in direct competition with the employer, or where the side business impacts on the employee's ability to do their job, the employee must definitely disclose. But what if the side business is not in direct competition with the employer? Or what if the side business does not necessarily impact on the employee's ability to do their job? What if the employee works Monday to Friday and they do something on the side over weekends? Is there still a duty on the employee to disclose? Now, in the recent matter of Bakenrug Meat, better known as Joostenburg Meat versus CCMA and others, the Labour Appeal Court dealt with the issue of whether an employee owes their employer a duty of good faith to disclose their side business in circumstances where it may constitute a conflict or where it might prejudice their ability to perform their work for their employer. Now, in this case, the employee was a sales representative in a business that produced and sold a range of meat products. The employee was dismissed after she was found guilty of a charge of dishonesty in that she failed to inform her employer that she operated a business of her own that marketed dried meat products. The employer also contended that she had failed to give full attention to the marketing the meat products it produced. The employee was unhappy with the dismissal, referred the dispute to the CCMA, and the Commissioner found the dismissal to be substantively fair. The Commissioner reasoned that since there was an alignment between the business of the employer and that of the employee, the employer should have at least been made aware of the employee's activities, and the fact that she chose not to make a disclosure of her business interest amounted to unacceptable behavior and an act of dishonesty. The employee was not satisfied with the CCMA's outcome, and she launched a review application before the Labour Court. On review, the Labour Court held that the CCMA Commissioner's finding was unreasonable. The Labour Court held that the Commissioner ought to have considered the employee's evidence that she only ran her business on weekends, and therefore there was no nexus between her performance and the running of her own business. The Labour Court accordingly set aside the Commissioner's award and ruled in the employee's favour. Essentially, the Labour Court's approach was that unless employees inform their employers that they are moonlighting to the extent that there is some competition with the employer's business, no dismissible misconduct had occurred. In other words, an employee had no duty to inform the employer about a potential conflict of interest. The employer wasn't happy with the outcome of the Labour Court, and they took the matter on appeal to the Labour Appeal Court. And the Labour Appeal Court overturned the Labour Court's decision on appeal. The reasons given by the Labour Appeal Court is the following. The Labour Appeal Court held that there was clear evidence that the employee did not disclose an essential and material fact that she was independently operating a business in marketing meat products, even if the meat products were not identical to that of the employer. The Labour Appeal Court held that the fact that the operating of the employee's business did not affect her performance was insignificant. What was important is that she was employed as a sales representative in a business marketing meat products, while she was also involved in marketing meat products. The Labour Court held that her failure to inform the employer of these activities amounted to dishonesty and a violation of her duty of good faith towards the employer. The Labour Appeal Court therefore found that based on the evidence, the Commissioner arrived at a reasonable decision that the dismissal was substantively fair, and the Court accordingly set aside the judgment of the Labour Court. Now, in conclusion, ladies and gentlemen, this case emphasizes the well-known principle that employees owe a duty of good faith to act in the best interests of their employer. For those of you watching this video, employers who are still operating on a remote working or hybrid model, I think it's important that controls are put in place to ensure that employees do not abuse their new working arrangements by using time that they should be dedicating to you to focus on their side business. If you need any assistance in this regard, please do not hesitate to contact us. Now that brings us to the end of this video. As always, thank you for watching, and I will see you in 2 weeks' time. Bye-bye.